Hello, this is Kid Malek from Malek Malek, attorney. Today I'm going to be talking about something that comes up in this time of year, and it's seasonal jobs. So you're going to see seasonal jobs and temp type jobs. So what do I mean by that? When you look at like the news, when I've looked at the news, I've seen an article where they're talking about, Macy's is hiring, X number of thousands of people. Amazon's hiring, tens and tens of thousands of people, and L brands, and all these kind of big warehouse type situations. So they're all gearing up for the Christmas season, and so they're all going to be hiring. And presumably those are going to be seasonal. So you're going to work. They start hiring up right now, and they start getting into gear like October, November, and then typically what I see when we get clients who are seasonal / temp workers is, they'll work like a number of hours each week, like more than 40 hours a week, and they'll be working 12 hours days, 5 days a week, 6 days a week, and doing overtime. So the question is, if you're a temp worker, can you get and you get injured on the job, are you going to be able to file a workers' comp claim? And the answer is, of course, if you work in Ohio and you get injured on the job, then it's going to be a workers' comp claim. So then the next question is because this is where some confusion comes in with these temp type jobs. And here's the thing with that. Let's say you start today and you've at some warehouse and you're working there, and then you're working and you've only been working there for 30 minutes, an hour, 2 hours, even a minute would be sufficient. Let's say you get there and then, you lift up a box. It's the first box that you lift up, and then you get a back strain or something. Even if you're only there for a minute, you could still file a claim. Now, I would suspect that there may be some credibility issue if you were to go to a hearing and you say, hey, I was only there for a minute, I lifted up the first box that I got, and then I got this back strain, and it's a seasonal job. It might be allowed, it might not be. In that instance, you'd probably go to the hearing and they'd probably want to know what you were doing before you were working at the seasonal job, and if there's any kind of discrepancies, that kind of claim is probably not going to be allowed. But irregardless, whether you're there for a minute or at a job for 100 years, you can still file a claim, and the same goes true whether you're a temp worker or a full-time worker. Now, where you wouldn't have a claim is if you're considered an independent contractor, and that's whether you're an independent contractor or an employee. That's like a whole other discussion for another video. But so let's say you're working at one of these warehouses, you lift up a box, and you get some kind of back injury. You're just going to do like what you would do if you're working, at a regular full-time job where you've been working there for years. You're going to let your supervisor know, your manager know, the people that are overseeing you, and then you're going to say, hey, I injured my back, and you'll file, if there's like an incident report form or something, they'll have you fill that out. If you're grievously injured, obviously you're going to have the ambulance or pick you up, or you're going to have somebody drive you to the ER. If you're not grievously injured, my suggestion is if you, obviously you got to do what you got to do, but if you go to the ER, at the base level, they're going to charge you like $1,000, $1,500 just to look at you for 5 seconds. So if you're cool with possibly being on the hook for that $1,000, $1,500, and that's money's not an issue for you, then you go to the ER, and it's not, or if it's an emergency situation, life or death, obviously go to the ER. But if it's not, my suggestion is go to some type of urgent care situation, some type of walk-up clinic, some type of pay as you go. You pay $100, they look you over. There's many of those in Columbus and around Ohio. So, ER, urgent care, walk-up clinic. It's just going to be cheaper, and they'll do all the same things that they're going to do at the ER. And I'll be honest with you, I destroyed this arm. I have, if I took off my jacket, you'd see this big line. I have a bar right there with 6 screws. I ended up going to the Grant ER. They looked at it for seriously, like 5 or 10 minutes. Um, Gave me, I think, a shot of some kind of. It wasn't a painkiller type thing, but some kind of something that it was like Toradol or something. So that I don't. That's not really a narcotic painkiller. But irregardless, got rid of the pain a little bit. And then they're like, okay, and I kind of thought that it was really like I had a rotator cuff tear, and they're like, do you want to do an X-ray? And I was like, nah. And so okay, well, go ahead, go home. So I mean, and bottom line is actually should have gotten the X-ray, but I didn't. But the point is that bill from that 5 or 10 minutes, and it said I saw a doctor. Did I see a doctor? I don't know. I thought I saw just a bunch of nurses, frankly. But it was like, I mean, I think it was like pretty expensive. Honestly, it was like $1,500, $2,000. It might have been more money than that. So that's the point with that sort of thing. The other thing, when you work at these big warehouse gigs, especially as like a seasonal worker, or you might have gotten the job through like a temp agency, like Minutemen. There's other ones like Adecco. I remember that when I was younger, and I did some temp jobs in the summer, Adecco, and these sorts of things. If you get injured, like let's say you're at some warehouse and you get injured, so the issue is who's responsible, because then the client, the injured worker is confused. They think like even if they're working at like say Amazon and they get injured at Amazon, then they think Amazon's responsible. And so that's, if you're working for a temp agency, the temp agency is actually responsible for the workers' comp claim. So they're the ones who are going to be fighting the claim, who are going to be disputing whether you're entitled to comp. Their managed care organization, through their workers' comp coverage, is going to be the one authorizing or not your treatment. So you work at, let's say for example Amazon, but you're actually working at that location through say Minutemen. So the claim is going to be against Minutemen's workers' comp coverage. You just happen to get injured while you're working on an Amazon warehouse. Why do these warehouses and these logistics places do that? Bottom line is it's probably to save money, put a shield between themselves and liability for things, and also it's much easier for them to boot people off the job. So if you're working for like one of these temp agencies and you get injured at a warehouse or something, they could just say, okay, we get rid of that, get rid of that person. You're still working for the temp agency, so the temp agency doesn't let you go. But, whatever the warehouse that had hired you through the temp agency, they're like, hey, we need you to fill somebody else in here. So it's going to be much easier for them to fill in that spot. Whereas if it's like you're working for them, they have to retain that position for X number of months through FMLA. So, they have to hold that position. After that point, they'd be able to fill it. But with this, if you're working for a temp agency, you're still working for the temp agency. You're just not placed at that place. And the other thing is, if you're working for a temp agency and you get injured working for a temp agency, they have depending on what businesses they work with, they might have a little bit more leeway or it might be easier for them to accommodate work restrictions if you have work restrictions by putting you at some other business. They might have some kind of arrangement with Goodwill and send you over to Goodwill. So instead of, if you have work restrictions, if you're working for some jobs, if you're working for some employer and you're working in some kind of a heavy labor position, if you get injured, you have your work restrictions, you might not be able to accommodate it. Whereas if you're working for a temp agency and you get work restrictions, they might have a little bit more leeway to accommodate those work restrictions and get you back to work, whether that's a good or bad thing, who knows, in that light duty position. So there's that. But yeah, the liability, I mean, it's kind of wonky. You would think like I got injured at, this cookie factory and, they should be responsible. But no, it would be the temp agency. So, but irregardless, the point is, and the overriding point of this whole thing is this Christmas season, when everybody's gearing up to work at all these different kind of temporary jobs, like right now this month you see these Halloween spirit warehouse things, which are always fun to visit, and they're always in some temporary location. So all those folks, they're temp workers. Once Halloween's over, obviously, Halloween spirit's not paying 100 million people, 11 months out of the year. So they're just hiring and getting rid of folks. So, if you get injured at Halloween spirit, you're, loading up costumes on the racks, and you hurt your shoulder or you trip on something on the ground. You would file it, and you would just have a claim like any other situation, no difference. And let's say the temp job ends, like the seasonal work ends. You still, just because the seasonal work ends, let's say you're working at, for example, Halloween Spirit, that Halloween costume company. November 5th, they might close November 5th or 10th. They might have some sales after Halloween, but then they're going to shut that down. So you think, oh no, they're shutting that down. My workers' comp claim is dead. I mean, that's not how it works. You're going to have your claim is going to keep on going on against, whatever that entity is of Halloween Spirit. So you'll be able to, collect workers' comp if you're entitled to it. You'll be able to get medical treatment if you're entitled to it. And you could, if you get seriously enough injured, that could go on for years. So whether or not that actual temp job disappeared or not, so you don't need to worry about that. But the other thing to think about with these when you're doing these seasonal type gigs, especially these massive type of warehouse things, is just be really, if you injure your back or whatever body part, don't just it's kind of like I always say, if it's like a weekend thing, fine, don't worry about it. But if it's more than a weekend thing, I think a lot of these places, they'll have these like kind of on-site kind of first aid things. Don't just rely on that first aid thing as your kind of work, because that's not workers' comp. That's just their first aid thing. So if you really have some problem, and the other thing is if you injure your back or your shoulder or whatever, and you just rely on that first aid thing, they might not have done good documentation of what actually happened. They might not really retain those records really well, so that you're like, hey, I got injured on this date here, and I went to this first aid station. And they may have a record that you went to a first aid station, but they might not have a record as to what was observed by the nurse or whoever's running that first aid station. So what you want, you could go to the first aid station, get whatever first aid they're going to do. But if it's more than a weekend injury, then like I said, you go to urgent care, walk up clinic, and get your stuff documented. Because that's the thing to know about all this workers' comp nonsense, is it's all about documentation. Everything is documentation. And it's what it comes down to, the success or failure of your claim is the documentation of the subjective complaints, but more so the objective findings related to the body part that's injured. So if you injured your shoulder, they have various provocative orthopedic tests that they do. They call objective findings, diagnostics, X-rays, MRIs, these sorts of things. So it's very important that you get that. And the other thing is, and this isn't really totally germane. This is germane to all workers' comp claims. But when you get injured, you really, 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 it's silly that this is the way it works, but you have to document or explain to the doctor, he or she, exactly where you got injured. And let me give you an example. So because this has come up recently in the hearing. So this individual had hurt their hand. I think they hit their hand against like some cart or something, and they subsequently developed pain and discomfort in that hand. So the claim was allowed. They had an allowed claim. It's allowed for like a wrist sprain, but they ended up developing further complications, which is how these workers' comp claims develop. You get sprains, and then you start diagnosing the more significant things. Now, the issue in this case was the BWC doctors, and they were referred to an orthopedic. They actually didn't see an orthopedic doctor. They ended up seeing a certified nurse practitioner, what's a physician assistant. I mean, I suppose that's okay, but the point is that PAC was like, oh yeah, this person has this positive provocative finding of, it's called a Finkelstein, and they have pain right there, and then an MRI that showed this swelling in this particular area of the hand, and therefore I think it's likely that they have this de Quervain's tenosynovitis, which is a condition. So the employer ended up having a defense medical exam, so they had their own doctor look over this person, review the records, and it came down to, on the initial ER records, it was like the person, this is the history, they call the HPI, the history of present illness. The person described to the emergency room that they hit their hand on the cart on the top of their hand. So and the way that they described it, it's kind of like not, I don't know if you do anything with boats, but you have port and starboard, and I don't know what I think port is. Well, to me, port was right, but I think it's actually left. And the reason why it's right to me is because I used to row crew, and I was the number. I think I was the person who set the pace. So for me, I was at the front of the thing. But when you look at it from the perspective of the people watching the boat, I would probably be at the back. But irregardless, so with anatomical things, there's kind of similar kind of. Instead of left, right, up, down, there's anatomical directions. So there's like dorsal, palmar, lateral, medial. And it kind of shows you where on the hand the person. So it's the dorsal part of the hand. So that means the top of the hand. And so the defense medical examiner had said, the top of the hand was injured, but it was more on the middle. The middle of the top of the hand, and that's what she described to me, this injured worker. And de Quervain's tenosynovitis is in the first metacarpophalangeal joints, and it would be so the place where they were claiming they were injured does not correspond with the condition being requested. Therefore, it should be denied, even though the condition, there's objective signs that exist, because their argument or their position is because they're saying they got here, not here. So they're saying they got, the injured worker saying they got here, possibly. I didn't really see it definitively. I kind of just said, when I read it, it was like top of the hand. But and when you look at the hand, I mean, the hand's not a big thing. So, but the point is, if you hit your hand here, like on the first knuckle, or you hit your hand on the thumb joint or something like that, you might say, well, that's the top of the hand. But if that gets in the record, it might end up screwing you up, because it might be that you need to get you actually hit yourself right here. And since you described like generically the top of the hand, or you weren't really clear, you might end up getting screwed up later on when you're trying to get whatever injured tendon or something exists here. And they're saying, well, you didn't describe it there. You described, it was indicated right here on these initial records. So bottom line is you cannot, you gotta be very specific, and that goes where you where you injure yourself, and then how you injured yourself too. And this comes up a lot with knees and stuff. Did you twist your knee, which would be important if you ended up getting a meniscal tear? Did you twist your knee? Because there would be, the twisting motion would be consistent with getting a meniscal tear, versus, did you hit your knee against the edge of a table? That wouldn't necessarily cause a meniscal tear. So you got to be really clear, and it's really kind of the level of specificity that the BWC requires you to describe your things, to me, is annoying and not fair and bizarre. And they've basically fetishized the body parts and where it is, and it really gets really nitty gritty and granular. Whereas if you end up hitting your hand, you would think, okay, I don't care. You hit your hand. If this is implicated, it's probably because you hit your hand, but instead they require, well, did you hit your right here? Did you hit right here? Did you hit right here? Did you hit right here? And so is it fair? I do not think it's fair at all, but that's the game that the BWC plays. So going back to things, yeah, temp season work, you can file a claim just like any other workers' comp claim. It may be against the big warehouse. It may be against if you got placed there by a temp agency, the claim might be filed against a temp agency. It doesn't matter. As long as you're an employee, somebody's going to pay. And if either of those entities were to go bankrupt, then the Ohio BWC would step in and they would be responsible for paying that. So you don't have to worry about that. And assuming the Ohio BWC doesn't go bankrupt itself, it's got however many billions of dollars, I don't think it's going to happen. And DeWine, I think they're discussing giving like 1.5 billion or some huge number of rebates back to employers. So, they have plenty of money, I guess. Bottom line is, but once you get everything documented, as always, I end up all these videos the same way. If it's not a weekend injury and it's just and it's not a weekend injury and it's kind of more complicated or it's more significant than just and when I say weekend, you have pain for 2 days and then it's gone. If it's more significant than that, consult an attorney, get an attorney involved. It's always going to help you more so than it's not going to hurt you. Come to us if you want to. There's a lot of other really great workers' comp attorneys in Columbus and around Ohio that you could go to too. Anybody who practices this, for any number of years, they're gonna know what to do and they're gonna know how to help you. So consult with somebody, consult with us, Malek Malek, consult with somebody else. I don't care, but you absolutely need to consult with somebody. And to do this stuff on your own is you're really playing with fire, and you can really significantly impact, success or failure of your claim. And then the other issue is, let's say you're like, I'm cool, I can do this all myself, and then it turns out that you get the claim either denied or significant conditions denied, and it has to be filed to court. One, you're going to have to, if a condition or a claim's denied, you're going to have to convince a law firm to get involved after the ship has sailed. So you're going to have to convince them, and that law firm may not be interested in getting involved with that issue after the fact, because they're going to have time. There's going to be time issues and whatnot. And then the other thing is, you might not be able to find a medical expert. It's a lot easier to get all your ducks in a row at the administrative level than once it's in court. Once it's in court, there's time frames. You have to disclose this person. If you don't disclose this person by this date, then they can't testify. So if you don't find a medical expert by X date, then you don't have a case. So, yeah. Anyways, as always, if you have questions, concerns, other issues, you can, give us a call, give us an email. Contact information is within the YouTube channel. And then it's October right now, so depending on when you're watching this, it might not be October anymore, but otherwise enjoy the Halloween season, then enjoy Thanksgiving and Christmas, and good luck, working at your temp gigs and seasonal jobs, and avoid the injury. But if you're watching this, you got injured, so hopefully you're doing okay, and hopefully you're able to get fixed. And if you're not fixed, hopefully you're able to get an equitable, fair solution to your work injury. So best of luck to you. Thanks for watching. See you next time.